Well, just to reiterate, thank you very, very much for coming this evening. I really appreciated it. And it's always a great pleasure and a privilege, actually, to speak at York LGBT History Month. It's a particular privilege to be included in what is an amazing programme of events. And I always want to thank the organisers of LGBT History Month in York for putting together such a fantastic programme of events. It's a real sterling effort they put in, and thanks to them for organising it. The focus of LGBT History Month this year is geography, mapping the world, and the choice of this theme by the organisers is based on their commitment, they say in the programme, to encourage an international perspective on the existence, contribution and diversity of LGBT people in order to reclaim our past and work towards a better future. And it's a focus, I think, is of vital importance. When we look out into the world and we see LGBT people being subjected to the most awful, degrading and inhuman forms of ill treatment simply because of their sexual orientation or their gender, I think we would all agree that shining a light on global discrimination around the world is vitally important. A global perspective, I think, a comprehensive perspective on LGBT discrimination in the world is the only way to challenge and end it. And that's what so many of the events in this year's programme focus on, and that's a really great thing. However, that said, the focus of my talk this evening is not very global, I'm afraid. In fact, it isn't going to stray much beyond the country we're in at the moment, the United Kingdom. I've been a bit naughty, some might say, in interpreting the theme of the History Month, Geography Mapping the World, as an opportunity to try and map the legal history of sexual orientation discrimination in the country I was born in, grew up in and live in, this one here, the United Kingdom. And when thinking about it and thinking about why I wanted to focus on this, I did ask myself, why have I chosen the UK? Why do I want to talk about the United Kingdom in a month that wants to look at the geography of the world? Because I know, for instance, that I could have come along here and talked about all those countries in the world, for instance, where same-sex sexual acts are still a criminal offence, and where for engaging in those sexual acts carries the harshest of penalties and punishments, including in some countries death. I could have also talked about what it was like being in some of those countries where if you held a meeting like this or you had a talk like this, we would all be looking at the door waiting for the police to arrive. We'd be worried about that, or we'd be worried about people coming in and being nasty to us, and perhaps us being dragged away either by them or by the police, arrested and tortured. So I know we can talk about the rest of the world. So I asked myself, you know, I imagine myself, here I'll be standing in this room in the University of York tonight on Valentine's Day talking about this. Why do I want to talk about the UK? Well, I think the reason is, and it's the thing I come back to time and time again as a historian of sexual orientation discrimination, is that if you are British, or if you've ever lived in Britain, this history is your history. The history of the UK is your history. It's part of you. It's part of what defines you, what makes you. It's the history on which your present is based. And if you experience sexual orientation discrimination in the UK now, today, that is an outcome of the past, the recent past you've lived through and the longer past that went before you. And for that reason, I do think it's important to remember the UK and remember its history in LGBT Month. And I believe in the sentiment of the late and I think very great James Baldwin, who said that history is not the past, it is the present. We carry our history with us, We are our history, and if we pretend otherwise, we literally are criminals. In other words, to forget your own past is criminal, and I agree with that. I came to think about our shared past in the UK really intensively last year when I was involved in writing the legislation that resulted in the pardoning of men who were convicted in the past for what we used to call homosexual offences. I got involved in that process when a bill, the Policing and Crime Bill, was passing through the UK Parliament. Originally, that bill contained provisions to grant posthumous pardons to those who'd been convicted for certain abolished offences in England and Wales, such as buggery and gross indecency. The provisions relating to England and Wales were the outcome of a campaign that had been spearheaded in the House of Lords by Lord Sharkey, who had previously attempted to, as something of a stepping stone mechanism, introduce legislation to grant a pardon to Alan Turing. You might remember this. That legislation didn't happen because Alan Turing was given a pardon via a different mechanism, the Royal Prerogative of Mercy. But the provisions in the Policing and Crime Bill, which eventually came to Parliament, depending on your views on pardons and whether you think pardons are a good idea, were tremendous, a tremendous step forward for those who'd been convicted of homosexual offences in England and Wales. They're a symbolic gesture, a way of acknowledging the mistreatment of people over many centuries. But what the Policing and Crime Bill did at the time it was introduced didn't relate to those people who had been convicted in other parts of the United Kingdom. They only offered posthumous pardons to people who'd been convicted in England and Wales. And during the passage of the bill, I discussed this situation regarding the rest of the UK, and in particular Northern Ireland, with Geoffrey Dudgeon. Geoffrey Dudgeon is a gay rights activist in Northern Ireland and also a Belfast city councillor. And we decided together to try and get provisions relating to Northern Ireland into the Policing and Crime Bill so that men who had been convicted of homosexual offences in the past would be given posthumous pardons. We were exceptionally fortunate in finding strong support for this endeavour in the stalwart Lord Lexton, who, despite the political controversy that could have resulted from the UK Parliament attempting to legislate for Northern Ireland at a time when the Northern Ireland Assembly was sitting, tabled amendments in the House of Lords to make provision for Northern Ireland. Something which triggered a series of events. It led to debates in the Northern Ireland Assembly, who, amongst those members of the Northern Ireland Assembly, eventually issued a legislative consent motion, the mechanism to allow the UK Parliament to legislate for Northern Ireland. And subsequently, the UK Parliament passed provisions into law relating to Northern Ireland. Now, we were very pleased about this because, well, at least in my view, the Northern Ireland Assembly would never ever have done this were it not for the strong nudge from Lord Lexton putting his amendments down in the House of Lords and the strong initiative of the UK Parliament. So it was very, very important. It was an important moment when the UK Parliament decided to legislate for Northern Ireland. But when I was writing the legislation that will eventually provide pardons to people previously convicted in Northern Ireland, the thing that struck me was the historical complexity of what we were trying to achieve. To write the legislation that was required to grant these pardons in Northern Ireland, I had to go back through statute law to as far back as 1634. I had to look at statute law that had been enacted by 3 different legislative bodies, and statute law that covered different jurisdictions. it was a really complicated process. So, for instance, the legislation will grant a posthumous pardon to any person that was convicted of buggery in Northern Ireland under an act passed in 1634 which made buggery an offence. But in 1634, when that act was passed, Northern Ireland didn't exist as a country. The territory that we now call Northern Ireland was then part of the Kingdom of Ireland, which had its own legislature, the Parliament of Ireland, that legislated for the whole of the island of Ireland. And for me, that raised a lot of questions about what we were trying to do in the UK Parliament, in London. We were legislating to grant pardons for people convicted under legislation passed by a different parliament in respect of a jurisdiction that no longer exists. And I'm not saying that that's right or wrong, legally or politically. It's for you to decide, members of the public who look at what Parliament does, but just to me that it was rather fascinatingly complex. And as I sat in the gallery of the House of Lords on the day that this provision was accepted by their lordships into the bill, and I was just overwhelmed by the complexity of the history and the geography we were dealing with, the history we were trying to put right in a country that exists in a form that didn't exist at the time that the things that we were trying to put right were happened. And so that's the history that I wanted to talk about this evening. I wanted to talk about this complexity of the United Kingdom. Now, just before I do, I'm sure I don't need to give you this rudimentary geographical lesson, but I will do for my own benefit because actually it's much more complicated than we ever want to admit. The UK we're in today is one country. It is a sovereign state. But in reality, it is in effect a quasi-unofficial federation. It is in effect a federal system made up of 4 jurisdictions. The jurisdictions are, of course, England, Scotland, Wales and Northern Ireland. England, Scotland and Wales are officially classified as countries. Northern Ireland is not a country, it is a province. The country has one national parliament in London, in Westminster. Scotland, Wales and Northern Ireland each have their own legislative bodies, of course, that legislate on matters that have been devolved or transferred to them, for which they have competency. The Scottish Parliament has more matters devolved to it than the other assemblies. The Northern Ireland Assembly is not currently sitting, and it hasn't been sitting for over a year since the last election. Now, when we talk about sexual orientation equality in the United Kingdom, these jurisdictions become even more complex in the sense that we can really always talk about 3. There are differences between Scotland, Northern Ireland and England and Wales. England and Wales being one jurisdiction for our purposes, because in respect of things like criminal law, marriage law or equality law, all these things I'll talk about in a moment, England and Wales is essentially one jurisdiction. Those matters haven't been transferred to the Assembly. And when we try and trace the history of sexual orientation discrimination across this small country of ours, these jurisdictions, as I say, they present us with serious complexity. So, to get an understanding of these complexities, I thought I'd take us back to the origins of statute law that came to regulate same-sex sexual acts in the UK. These origins of the regulation of homosexuality are to be found at a time when the UK as a country didn't exist. They're before the Acts of Union in 1706 and 1707 that united England and Wales with Scotland, and they're before the Acts of Union in 1800 that united Great Britain with Ireland. The origins of the regulation of same-sex sexual acts by the criminal law in England and Wales are to be found in the first half of the 16th century. in an Act of Parliament passed in 1533 that criminalised what it politely called the detestable and abominable vice of buggery committed with mankind or beast. This statute put for the first time into English criminal law a provision that made it a criminal offence punishable by death for people to engage in particular sexual acts with humans or other animals. The sexual act in question, at least when it involved humans, was anal intercourse, specifically the penile penetration of the anus, which, until a change in the law in 1828, needed to involve what the law coyly called emission of seed to be an offence. Buggery could be committed between two men or between a man and a woman, but not between two women. Now, the buggery offence had existed in ecclesiastical law long before the Parliament of England sought to make it a criminal offence in England. And the reason why Parliament did make it a criminal offence in statute law in 1533 is generally understood today to be one of the ways in which the Parliament of Henry VIII sought to remove the powers of the ecclesiastical courts and the clergy that administered them. So several historians have argued, I think quite persuasively, that the legislation was designed to prosecute Catholic clergy for the offence, and then, having subjected people that were convicted to death, allow the state to seize their chattels, goods and possessions. The 1533 statute was not originally enacted as a permanent piece of law. It was originally enacted to run only for the term of one Parliament, but it was subsequently reenacted by Parliament in 1536 and 1539 until it was made perpetual in 1540. It didn't stay perpetual for very long because it was repealed by the first Parliament of Edward VI in 1547 and replaced with another statute by his Parliament, and his statute was repealed 5 years later by the Parliament of Mary I, and it was only Elizabeth I who restored her father's buggery law to the statute books in 1563, where it would stay in some form or another for about 450 years. By the time that this law was enacted by the Parliament of England at this time, in the 16th century, English criminal law was also formally extended to cover the whole of Wales. It coincided with that change. So buggery law was truly English and Welsh law. But it did not extend to Scotland or to Ireland. Similar offences did come to exist in those countries, but in very different forms. In Scotland, no offence has ever existed called buggery. In that jurisdiction, sodomy developed as a common law rather than statute law offence. One 17th century commentator, George Mackenzie, said that Scotland had no statute law on sodomy because it was a crime extraordinaire and rarely committed in this kingdom, unlike in England. The offence of sodomy in Scotland, unlike the buggery offence in England and Wales, only related to sex between men. Sodomy was not, unlike in England and Wales, an offence that men and women could commit together. Once Scotland became part of the United Kingdom, this created a great jurisdictional complexity insofar as acts of anal sex between men and women were completely criminalised in England and Wales until 1994, but always legal in Scotland. The statute enacted by the Parliament of Ireland, which I mentioned earlier in relation to the pardons in 1634, closely mirrored English law on buggery, making anal intercourse between men and between men and women a criminal offence. And the law of England, Wales and Ireland was eventually consolidated, brought together by the UK Parliament in respect of buggery in 1861, when the Parliament of Ireland ceased to exist. The only criminal law that has ever covered same-sex sexual acts and extended to the entire United Kingdom was Section 11 of the Criminal Law Amendment Act 1885 that criminalised acts of gross indecency between men. This law did extend to the whole of the United Kingdom because of the time in which it was enacted, the United Kingdom Parliament at that stage being the only legislative body for the United Kingdom. But as I say, it has been the only piece of law, criminal law, that has ever covered the entire UK. Now, the thing about these jurisdictional complexities is that by the mid-20th century, when the UK Parliament got around to try and consider whether it should start to partially decriminalise sexual acts between men, it was confronted by this amazing array of differences across the UK. So, for instance, at the time of the Sexual Offences Act 1967, which I'm sure you know was the act which for the first time partially decriminalised sexual acts between men, previous legislative developments had meant once again all of the UK was covered by different law. England and Wales had consolidated its criminal law in the Sexual Offences 1956, and the rest of the UK was still covered by Victorian legislation and by common law. Now, although the UK Parliament in 1967 had complete authority, if it had wanted to decriminalise same-sex acts between men across the whole of the UK, it chose not to. It chose to do so only in respect of England and Wales. In other words, Parliament took measures to permit men to have sex with each other only in certain conditions. They had to be in private over the age of 21 and be in circumstances where no more than two persons were present. But they decided to do that only in respect of England and Wales, and to leave those acts completely criminalised in the rest of the UK, in Scotland and Northern Ireland. Now, the serious consequences of this approach were not lost on some MPs, on some parliamentarians at the time, who sometimes to the amusement of their peers raised the issue in practical terms. Raymond Morby MP, for instance, was concerned about the implications of partially decriminalising sexual acts in 1967 between men in England and Wales, but not in Scotland, because of what might happen if people engaged in these acts whilst travelling in a sleeping compartment on a train that was travelling between England and Scotland. And Mr. Morby questioned the Home Secretary in the House of Commons very robustly on this issue. He says the bill does not apply to Scotland. Night sleepers regularly run from Euston to Edinburgh, Glasgow and so on. Perhaps the Right Honourable Gentleman will tell me what the situation will be. The important thing is that two passengers who occupy adjoining sleepers after boarding a train at Euston are committing no breach of the law if they indulge in this practice. But as soon as the train crosses the border and goes into Scotland, they are committing an offence. Is this the right way to leave a bill? Are British Railways sleeping car staff to receive special instructions to blow a whistle at the border? And one MP shouted out rather amusingly, the advice they should be given on the train is, stop at Carlisle. The jurisdictional complexities of the UK, though, meant that the criminalisation of certain sexual acts were absurdly different across the UK until very recently. So, for instance, same-sex sexual acts between men were partially decriminalised in England and Wales, Scotland and Northern Ireland at dramatically different times, between 1967 and 1982. Buggery, as I mentioned earlier, between a man and a woman was partially decriminalised in England and Wales in 1994, but remained completely a criminal offence in Northern Ireland until 2003. In both cases, decades after men had been permitted to engage in these acts together. The offence of buggery itself was repealed in England and Wales in 2003, in Northern Ireland in 2008, and sodomy abolished in Scotland in 2009. And gross indecency was repealed also at different times. And I think what this shows is that the UK, when it comes to the development of law reform designed to end sexual orientation discrimination, has never had a common approach. Although sometimes a development in one jurisdiction triggers a development in another jurisdiction, it isn't often automatic, and often it's very hard fought and very difficult to achieve, and it often does rest on one or two people, such as Geoffrey Dudgeon in Northern Ireland, intervening and saying, hang on, what about us? What about Northern Ireland? Northern Ireland is, I would say, consistently forgotten and left behind. It's the place that's overlooked in our country, in our United Kingdom. And the clearest example of that is, of course, in relation to same-sex marriage, where Northern Ireland lags behind. Same-sex marriage, as we know, was legalised in England and Wales in 2013 and Scotland in 2014, but remains completely illegal in Northern Ireland. Marriage is a matter transferred under the current devolution settlement to the Northern Ireland Assembly, so it's up to the Northern Ireland Assembly to make same-sex marriage lawful. Now, the Assembly has shown an interest in doing so. It's debated and voted on the matter 5 times, most recently in 2015, when a majority of its members actually voted in favour of a motion calling on the Northern Ireland Executive to legalise same-sex marriage through legislation, but a motion that was eventually suppressed by the use of the petition of concern in that Assembly. The problem is that Northern Ireland now doesn't have a sitting assembly to keep debating this issue and getting around to passing the legislation. So while same-sex couples can marry in the rest of Great Britain, they're denied what we would probably agree is a fundamental right, a fundamental human right in one part of our own country. And that produces all sorts of complexities for people and problems. It means that if a same-sex married couple move from Birmingham to Belfast, which is just moving within one country, by the time they get to the other part of their country, their marriage has mysteriously disappeared. It ceases to exist. They're no longer married. They would be regarded as civil partners. They come back to Birmingham, they're married again. It is a quite ludicrous situation to be in one jurisdiction. There is a very simple way this could be resolved, and I've even written a bill to achieve it, and I've tried to get some politicians interested in it, extremely unsuccessfully so far. But all that needs to happen to rectify this situation is that the UK needs to enact my nicely crafted legislation which would take back control for marriage in Northern Ireland. It would make it a reserved matter for the UK Parliament, and then the Secretary of State would be compelled under this Act of Parliament to make regulations enabling same-sex marriage in Northern Ireland. Now, if you're a supporter of devolution and you're a supporter of assemblies and parliaments across the UK, this kind of argument may result in one or two of you throwing furniture at me, because in fact what I'm saying is to use that dreadful phrase that the UK Parliament ought to take back control. I know that is a dreadful phrase these days, but the question I ask is, if you're against the idea of the UK Parliament legislating over Northern Ireland on this issue, what is your justification for it? What's the justification of leaving people in one part of the United Kingdom to suffer discrimination simply because there is no functioning legislator there to pass the legislation? And I'm afraid that people do continue to suffer different levels of discrimination across the UK based on their sexual orientation because of inconsistencies and irregularities in our laws. I was trying to think of good examples of this, and I think this is a pretty good example. The example is the different level of protection that are available to you in the UK for regulating what we commonly call hate speech against people because of their sexual orientation. We have a complex, multifaceted framework in the UK for dealing with this. For instance, in Northern Ireland since 2004, words, behaviours or materials that are threatening, abusive or insulting have been an offence if a person intends to stir up hatred or arouse fear, or hatred is likely to be stirred up, or fear is likely to be aroused. There is a similar offence in England and Wales, but it is much more narrowly drawn. In England and Wales, words, behaviour or materials have to be threatening only, and they must be intended to stir up hatred. Now, there are a number of important differences between English law and Northern Irish law. For instance, in English law, you can't commit a criminal offence if you arouse fear of a group. It has to be hatred. Also in English law, there are statutory protections for particular types of speech which are not relevant to Northern Ireland. So, for instance, you cannot commit an offence in England and Wales if you criticise people for their sexual conduct or practices in public and urge them to refrain from them. Nor can you commit a criminal offence in England and Wales if you make a remark about same-sex marriage. But those protections don't or are not relevant in Northern Ireland. In Scotland, there is no offence whatsoever. No bespoke offence. There is one offence in Scotland that's relevant, and that relates to an offence that was enacted in 2012, which regulates expressions of hatred or stirring up hatred against a group of persons or an individual on the grounds of sexual orientation if it takes place at a regulated football match. So that is only one space where the law provides that bespoke protection. Now, arguably the aim of all of this legislation, the thing it has in common, is that it wants to protect people, primarily non-heterosexual people, but perhaps heterosexual people as well, from forms of speech that are designed to stir up and promote harm against them as a group on the basis of their sexual orientation. If people need this protection, which in my opinion they do, why do we not have a uniform law across the whole of the United Kingdom? Why are there three different legal regimes that offer different levels of protection? We can ask that question in respect of the three different legal regimes. If I go back to this example of pardons, and we look again at what's in place or planned across the three different regimes in respect of addressing the wrongs done to those people who have previously been convicted of homosexual offences. I mentioned pardons, as I say earlier. Pardons are a mechanism essentially for saying sorry. They're a symbolic system. They're a way of saying to a person, living or dead, who was convicted or cautioned under old homophobic laws, we're sorry. But there's also a system in place called the disregard system, which people use to have convictions that they're living with disregarded by authorities. So people who are living today, who have a criminal record with one of these old offences, can apply to have those convictions essentially struck off their records. They remain on their records, but they come for all purposes disregarded. Now, unfortunately, the legislation relating to these disregards and pardons has been introduced at different times and by different parliaments, and as a result will mean serious differences across the UK. And the result will be that people have different access to pardons and disregards depending on where they were convicted or cautioned. So, for example, in Scotland, if the legislation that's currently going through the Parliament is passed, any person who's been convicted of a historical sexual offence, whether they're living or dead, will be pardoned for the offence if the conduct constituting the offence, i.e. what they did, would not be an offence today. It's quite clear. If you committed an offence in the past that wouldn't be an offence today, you'll get a pardon. So the pardon will be automatic. In England and Wales, if you're living with a conviction for one of these offences, you don't get your pardon automatically. You have to first apply to the Home Office for a disregard before you get the pardon. If you don't get the disregard, you don't get the pardon. Now that to me is absolutely stupid. It's ludicrous. Why should a person living with a conviction for gross indecency in Edinburgh be automatically pardoned when the same person, if they were living with the conviction in Exeter, have to go through a fairly complex bureaucratic process which they might not be able to achieve in order to be pardoned? That makes no sense to me. The proposed Scottish framework also covers a much greater range of offences than the English legislation. That law covers, the Scottish law, if it's enacted, will cover any offence under which a person was convicted, not just the bespoke homosexual offences. In England and Wales, the law is narrow. And so as a result of that, I worked very closely with Lord Cashman to have provisions put into the Policing and Crime Act that allow the Secretary of State for England to change the law to widen the offences that people can be pardoned under. But so far, despite Lord Cashman's excellent work, no progress has been made. The provision is in law, but the Secretary of State has not used it. No regulations have been made. That means at the time the Scottish legislation comes into force, there will be 3 different pieces of legislation in the UK, and people will be granted pardons and disregards under completely different provisions. Now, as I say, to me that's ludicrous, it's silly, it doesn't promote justice, which is the intention of these measures. It actually continues unfairness. So what's the answer to this? Well, the answer is the thing that gay men and lesbians have been doing in the UK for a very long time. The answer is you have to resolve the jurisdictional discrimination by going to court. And people have done this time and time again. So people go to their regional courts, or their national courts, if you like, country courts. In 2012, a challenge was made in Northern Ireland, in the Royal Courts of Justice there, to a measure which debarred same-sex couples from jointly adopting a child. Same-sex couples were not debarred from jointly adopting a child in the rest of the United Kingdom, but it was illegal in Northern Ireland. So a challenge was made successfully, and the High Court in Northern Ireland struck down the relevant statutory protections. The Supreme Court in London is the place probably where same-sex couples in Northern Ireland will go to try and get marriage equality. Go to the Supreme Court to say, we live in one country, why can we not have this here when the rest of Great Britain, rest of the United Kingdom has it? And then, of course, there's the European Court of Human Rights in Strasbourg, the place that people end up in to complain about discrimination within the UK itself. That being the famous place in the 1980s, which forced a change in Northern Ireland to legalise same-sex acts between men in the early 1980s to bring Northern Ireland in line with the rest of the United Kingdom. Now, of course, people can do that, but it raises the question, why should people in one country, that live in one country, have to go through the extensive investment in time and money of taking their governments to court on the basis that there are differences across these jurisdictions? That, to me, again, is not fair. I think what we should focus on is the fact that we are united in our United Kingdom by certain protections of human rights and fundamental freedoms that arise from the European Convention on Human Rights, which the UK signed in 1950 and gave further effect to in the Human Rights Act 1998. The Human Rights Act is our mechanism for ensuring that people are treated equally across the whole of the United Kingdom, and it should set the standard. Where you have a right in one part of the United Kingdom, it should follow in other parts of the United Kingdom. That doesn't seem to work at the moment, and I suppose I would conclude by saying that because it doesn't work, what we really need to do is to think about the country we live in and what we need to do to ensure fairness across the whole of it. I think we need to reconceptualise our approach to equality in the UK. You may support devolution. Most of us do. You might like the Scottish Parliament, the Northern Ireland Assembly, the Welsh Assembly. You may be in favour of greater devolution. You might even be in favour of the breakup of the United Kingdom, or you might wish to strengthen it. And it's not for me to sort of go on about these issues. That's for all of us to decide on our own. But at the moment, we do live in a United Kingdom, and it's one in which equality isn't delivered fairly amongst the people who live in it. The political and legislative settlement we have doesn't work. We can see that. It produces legislative complexities that perpetuate unfairness and result in further discrimination. We need a common approach to this. We need some form of UK-wide authority that regulates equality issues to ensure that everyone in the UK is treated fairly and equally. We need perhaps legislative reform. Perhaps equality issues should not be transferred matters or devolved matters. We need something. We need, to use an old-fashioned phrase and one that's not commonly used, a one-nation approach. If we live in a United Kingdom, then let's be united and let everyone be treated fairly and equally. Thank you very much for listening.